Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Lina Nur Hikmah binti Muhammad Asnawi and my matric number is 2210230. Today I would like to discuss about the topic the power of civil court and Sharia court. Before that, let me begin with the meaning of the court. The word court means an institution responsible for administering justice and resolving legal conflict. It is a place where trials are conducted and the judicial system make a decision. The objective is to ensure the compliance with the law and protect the right of individuals. The Sharia court handles matters related to Islamic law like family issues and the inheritance. It operates in region where Islam is predominant with three levels: the Sharia High Court, Sharia Lower Court and Sharia Court of Appeal. Each state in Malaysia has its own Sharia court system with a special main Sharia court in Perak. On the other hand, the civil court deals with non-criminal cases such as contract and divorce. It follows a familiar court structures with Superior Court, High Court of Malaysia and subordinate court yakni section court. Although separate, the Sharia court and the civil court are closely connected. They represent Malaysia's dualistic legal system, blending civil and Islamic law to ensure fairness and justice in society. Before independence, Malaysia had Sharia court which handled cases and appeal to the king. These courts were rooted in Islamic law and addressed personal and family matters. During British colonial rule, the civil legal system was introduced alongside colonial court based on English law. The first high court were established in Penang, Singapore and Malacca. In 1948, the Supreme Court of Malaysia was established, serving as the highest court in Malaysia. The Sharia court were separated from the federal court in federal court system. In 1948, becoming state court under the court ordinance. Upon achieving independence in 1957, Malaysia established civil court which each state introduced Sharia court under Islamic religious administration law. In 1994, the federal court was renamed the Court of Appeal, with the highest court becoming the federal court. Since then, Malaysia's court system has evolved to meet changing societal and legal demands with an increase in court and the integration of technology.
My name is Nurul Atira binti Ramli. Then I will continue about difference between the jurisdiction of the Sharia court and the civil court in Malaysia. First, hierarchy of the Sharia court and the civil court in Malaysia. Second, legal basis Sharia court and civil court. Third, the jurisdiction of the Sharia court and the jurisdiction of the civil court in Malaysia. There are different hierarchy of the Sharia court and the civil court in Malaysia. Hierarchy of the Sharia court in Malaysia is which are Sharia Appellate Court, Sharia High Court, Sharia Subordinate Court. Next, hierarchy of the civil court in Malaysia. First, Federal Court. Second, Court of Appeal. Third, High Court. For the legal basis in Sharia court and civil, in Sharia court in Malaysia, Al-Quran, Al-Hadith, state law and enactment, canon and fatwa, principle of fiqh. Then, civil court in Malaysia, Constitution of Malaysia, civil and common law, law of equity, which mean justice and welfare. Next, precedent case and principle of justice and humanity. For third, different of the Sharia court and civil court is the jurisdiction of the Sharia court and the jurisdiction of the civil court in Malaysia. Sharia court in Malaysia, the jurisdiction of the Sharia court in Malaysia is involved the trial and addition of case involving Islamic law. In Malaysia, the Sharia Court as an authority to hear and decide cases in the field of matter including marriage, divorce, graduation, adoption, trust, Malay custom and Sharia offence. Next, the Civil Court in Malaysia. The jurisdiction of the Civil Court in Malaysia is divided into two categories, namely the High Court and the Lower Court. The High Court consists of the Federal Court, the Court of Appeal and the High Court, while the Lower Court consists of the Session Court and the Majestic.
My name is Nur Alia Natasha binti Ismail and my matric number 2216624. Now we will look at the conflict jurisdiction between two powers, Sharia Court and Civil Court. By referring to the main schedule, matters of law containing Federal List 1, which is in the area of Civil Court, and State List 2 specifically for Sharia Court. Thus, the Sharia Court is a state-created institution that should be specifically bestowed by state legislators, and it needs to have an official conferment from state legislator itself to be able for them in handling the cases for the existing provision they had arrived at. This shows a hardship moment for Sharia Court, meanwhile Civil Court being a supreme law people frequently refer to. Next, the main arising issue for jurisdiction between two powers was when a contradiction occurs with the supreme law and makes the other less powerful and void automatically, as it is against the existing power in the Federation. In addition, to solve this issue, the amendment of Article 121(1)(a) has been implemented for appeal purpose, which is to protect and raise the position of Sharia Court. Hence, there will be no interference from any parties anymore. Yet, this is not the end because of the absence of special provisions given to the Sharia Court to handle the related cases such as apostates. Yet, this is not the end because there were different interpretations among certain parties about the amendment of Article 121(1)(a), narrowing down the scope of Sharia courts jurisdictions against the perfection of Islam, which is known as Shumul itself. In short, the position of Sharia court is good, but then there are still some parts that are lacking due to various interpretations from people, and especially the court according to the cases are different jurisdiction, whether the decision is handled by the Civil Court or Sharia court at the end. For further discussions, let's go for the cases explanations after this. I will pass to the next presenter. Thank you.
Apostasy and legal challenges in Malaysia. Apostasy involves the act of leaving religion or political belief. From the Sharia Court, they received more than 863 cases related to apostasy by 2010, sparking debates on the extent of individual right to choose their religion with the country. In the Quranic ayah from Surah Al-Baqarah verse 217, it emphasized severe consequences for those who turn away from Islam. However, the practical application of this verse varies across Malaysian Islamic court, with different states having varying law and punishment related to apostasy. Famous example about the cases apostasy, which is Lina Joy. She is a Muslim by birth who converted to Christian, that he faced a legal dispute in Malaysia when she saw official recognition of her new faith. Despite her attempt to change her religion status on official documents, she encountered obstacles under Malaysian law, including the denial of her application to switch her religion status to her national identification card. So, in conclusion, we can conclude that through the case of the Islamic law about the Lina Joy, there are still many shortcomings in the operation of Sharia law in Malaysia, where not all states actually apply this law.
Hi Nisrin. I just read that the federal court today ruled that the conversion of 3 children of kindergarten teacher M. Indira Gandhi almost 10 years ago to Islam is void and legally invalid. Did this conversion impact the status of marriage on both spouses that might be dissolved?
Thank you, Robert. In answer to your questions, you have to know that there are several legal complications that still arise until today. For instance, the status of the marriage, the maintenance of the children, and also their education, and especially minors, the determination of the child's religion under the age of 18. Similarly, the case of Indira Gandhi versus Pengarah Jabatan Agama Islam Perak and others 2018 1 MLJ 545. The main issue is whether the High Court had jurisdiction to hear the case, or whether power to declare the status of Muslim persons was within the exclusive of jurisdiction of Sharia Court. Generally, Indira Gandhi anak perempuan Mutu, who is wife to Panamatan, anak lelaki Krishan, her husband contracted a civil marriage under the law reform, Marriage and Divorce Act 1976. Then, the side from Indira Gandhi, her party found that the Register of Mu'allaf does not have the authority to issue certificate of conversions of children to Islam because they do not in line with Section 96 Clause 1 and 106 Clause B of the Perak Islamic Religious Administration Enactment 2004. These sections each stipulate that a person must recite to Shahadah, Ashhadu an la ilaha illallah wa ashhadu anna Muhammadar Rasulullah, in Arabic clearly and voluntarily, while children who have not yet reached the age of 18 can embrace Islam if they get written permission from their parents or guardians. And also, Indira Gandhi felt disappointed by her husband's action because Panamatan anak lelaki Krishan was hastily to make a decision. When this happens, there is still a dispute between the two courts about how to manage the matter because one couple has converted to Islam but the other has not. To summarize this case, I agree on what have mentioned by the one author on his research that she said from Islamic aspect that Malaysia must establish a special court of mixed jurisdiction where both Sharia and civil judges will adjudicate disputes involving Muslim and non-Muslims on the issue of custody and of the children of conversions.
To conclude, about the fact our country has announced Islam as the official religion of the Federal Constitution, but this does not affect the rest to be all Islamic in all matters. In terms of legislations, most Muslims might feel not satisfied with the state of these bilateral jurisdictions, which appear to be one-sided, which are much more prioritizing laws other than Islam, which are only given limited jurisdiction, especially when it comes to conflict jurisdiction issues. Absolutely, we are not to deny this kind of problems are not supposed to happen at all, as the two powers must get their rights justly to avoid conflict and contradiction, and both of them have the same good intention for a common good for all. Apparently, the conflict between both powers, which is Sharia court and civil court, are difficult to discuss further because even though there was an amendment of Article 121A making a clear borderline to separate and avoid interference from one of another, yet it did not really help to solve this jurisdiction issue. Hopefully for upcoming days, there will be something to do to solve and improve these jurisdictions powers between these two, such as efforts in unifying the civil and Sharia courts, which is to elevate the position of Sharia courts to federal courts and appoint judges who are trained in Sharia law and civil law as well. If there is a mix of cases involving Sharia and civil law issues, then these two judges can discuss together. Thank you for your attention hearing this presentation until the end, and Assalamualaikum warahmatullahi wabarakatuh.